Basic principles of American Constitution. The United States Constitution is the world's oldest living constitution. This document is still the cornerstone of American democracy after more than 230 years. Despite the addition of 27 amendments to the Constitution, the fundamental principles embedded in this historical document remain today. This is a truly remarkable accomplishment. These principles provide endurance and stability to this young nation. They have become an essential part of the national character and political culture of the United States. The basic principles are: popular sovereignty, natural rights, limited government, separation of powers, checks and balances, republicanism, and federalism. Number 1. Popular sovereignty. Where does the legitimacy of the government come from? The phrase "we the people" began the Constitution. This reflects the concept of popular sovereignty and consent. The people grant the government the authority to rule. Thomas Hobbes, an English philosopher who lived in the 17th century, first proposed these two concepts. Hobbes developed the idea of sovereignty, or the right to self-rule or self-government, in his book Leviathan. Individuals governed themselves before humans established an external government. As a result, the people have sovereignty. People eventually cede some of their sovereignty to an external government to maintain peace and security. This is also accomplished through a community agreement or social contract, with the people's explicit or implicit consent. This is also known as popular consent. Number 2. Natural rights. Where is the boundary line for governmental power? Individual freedom and individual rights are embodied in the Constitution and its amendments. According to the Declaration of Independence, people have certain inalienable rights, such as life, liberty, and the pursuit of happiness. These words are from John Locke, another English philosopher who lived in the 17th century, and are associated with natural rights ideas. Natural rights advocates believe rights are independent of laws, customs, or government. These rights are bestowed upon people at birth. Natural rights were developed as part of the social contract theory during the Age of Enlightenment. According to John Locke, natural rights include life, liberty, health, and property. Natural rights are universal and inalienable birth rights. They are not a privilege that can be taken away. They belong to the natural law tradition. The legal system grants legal rights, which can be modified, deprived, or retrained, such as the right to vote. They are the benefits of being a member of society. These are typically civil rights, rather than natural rights. Number 3. Limited government. How to avoid a tyrannical government. The idea of limited government has two connotations. First and foremost, the primary goal of government is to protect people's natural rights. It does not have to be extremely powerful to be a detriment to these natural rights. Second, the government is subject to the law in the same way that the subject or citizens are. No one is above the law. The Constitution is the supreme law that limits the government's scope and power through delegation and enumeration. The limited government's primary goal is to prevent tyranny and absolute power. For this purpose, the American founding fathers devised a system of limited government based on political power fragmentation and decentralization. Number 4. Separation of powers. The division of labor among different power holders. Since French political thinker Baron de Montesquieu coined it, it is also known as the political triad or trias politica in French. Montesquieu lived in the 18th century. He believes that the best way to prevent tyranny is to establish a government whose powers are limited by law. Such a government must be divided into separate and independent branches based on its three main functions: legislative, executive, and judicial. This three-tiered system has served as a model for modern states. The legislative branch is in charge of making laws. The executive is in charge of enforcing laws, while the judiciary resolves legal disputes. Its goal is to prevent the concentration of all political power in the hands of a single tyrant. Articles I, II, and III of the Constitution separately vest three authorities. Unlike the British system, where there are no strict separations, the American political system is based on strict separations. No members of each branch cannot simultaneously serve in the other two branches. Congress cannot remove the president for political reasons, and the president cannot dissolve Congress. Number 5. Checks and balances, the system of balance of powers to prevent the abuse of power by each branch of the government. Another principle of government is checks and balances, in which every branch is empowered to prevent actions by other branches and is induced to share power. It established a power balancing system to allow the three branches to check on each other. For example, Congress can pass laws, but the president has the authority to veto them. The veto power is a legislative power granted to the executive branch in order to keep Congress in check. When Americans first proposed the concept of separation of powers, they did not implement a strict separation system. Instead, the authorities were further splintered. Each branch is given powers that the other two branches do not have. This system of power balance is known as checks and balances. It is also known as the Madisonian model. James Madison pressed the need to use the ambition of one branch to check the ambition of another so that no one branch becomes too powerful or tyrannical. The framers of the Constitution was first to implement such a system in the world. They did so with a lot of creativity. Instead of a total separation of power, what they laid out was actually a system of separated institutions with shared power. Number 6. Republicanism, what form of democracy is more desirable? The word democracy was never used by the framers of the Constitution. Instead, it advocates for Republican government at both the national and state levels. The rule of law and representative democracy are central to republicanism. The term republic is derived from the Latin term res publica, which means public thing or constitution. A republic is preferable to a direct or true democracy because it relies on the rule of law to prevent majority tyranny and the rule of a few, a small group of elected political elite who are held accountable to the wishes of the people. Civic republicanism, the idea that citizens should stay informed about politics and participate in the process, is the foundation of modern republicanism. Number 7. Federalism, how political powers are shared between the national and state governments. The 13 states and their people created the United States after declaring independence from the British. Initially, a confederal government was put into place. After 8 years of experimenting with it, the framers abandoned the system and adopted federalism as the new principle of government. The national and state governments will exist parallel to each other and maintain dual sovereignty. Each has its own separate powers, delegated and reserved powers. But not all issues were resolved about who have what authorities and whose laws are supreme. The state government fought with the national government for more than a century to reconfigure these issues. The federal government has gradually nationalized many issues and taken some of the powers away from state governments. Thanks for watching. Please like and subscribe to this channel for more information videos like this.